The appeal filed by the Economic and Financial Crimes Commission against the Kogi State High Court's ruling prohibiting the anti-graft agency from detaining Yahaya Bello, the immediate past governor of the state, was heard by the Court of Appeal on Monday. Of course, in the February 9th, 2024 decision, the Kogi Court ordered the EFCC to refrain from inviting, arresting, detaining, or prosecuting Yahaya Bello while his basic rights lawsuit was being adjudicated. The former governor is being charged on 19 counts by the anti-graft agency with money laundering, breach of trust, and theft of funds totaling about 84 billion naira. To force Bello to answer the authorities for his purported offense, the anti-graft agency went to the Federal High Court in Abuja.
Meanwhile, the White Lion, as he's fondly called, has spoken from his hideout through his lawyers who represented him, stating that he's ready to appear before the Federal High Court in Abuja to answer to the 19-count charge brought against him by the EFCC. But he's afraid of being arrested when he appears in court, although the EFCC has pledged not to arrest the former governor should he appear in court. The FCC has come under fire by a cross-section of Nigerians following the arrest and prosecution of popular socialite Pascal Okechukwu, a.k.a. Cubana Chief Priest, and Okuneye Idris Olarinwaju. Now, these are some of the stories that have been swirling around in the social media space and in the news, looking at the work that the EFCC has been doing. And joining us to speak on the extent of the law regarding this is Enyanwile Abednego, a seasoned lawyer and legal practitioner. Good morning, Mr. Enyanwile. Thank you very much for joining us.
Morning.
All right.
Good morning to your team there. It's a pleasure to be on you.
It's a pleasure to have you. Let's start with the Yahaya Bello conversation and go back to the beginning. Exactly what exactly happened? Now, if you recall, the defense that was being put up to sort of support him in a way, quote unquote, resisting arrest, is that there was an earlier judgment by the Kogi State High Court refraining or restraining the EFCC from effecting any investigation or arrest. However, we did see that a warrant of arrest was then issued by the Federal High Court in Abuja. So what exactly was going on? Did the earlier judgment by the court in Kogi, should it have nullified the warrant of arrest that was later on issued?
What we see going on is simple. If you check and let me follow this trend, if you look between A and D, you will find what is happening here. It's all sensation. It's all people trying to whip up sentiment. And it's an abuse of the entire court process. We do not know for sure at this time that the order of the Kogi State High Court has been vacated. We do not know. So relying on the warrant of arrest issued by the Federal High Court, when there's a standing order, whether rightly or wrongly, orders of court must be obeyed. It's an abuse of the court process. And you know, these are the things we Nigerians have become accustomed to or become used to, that agencies of government who should ordinarily stand to respect the rule of law, protect the rule of law, are now in flagrant disregard for the rule of law and the legal process. So I wouldn't say, sitting here as a lawyer, that the warrant issued by the Federal High Court has nullified or invalidated a valid order of the Kogi State High Court. Let me even say this, just for the benefit of doubt. I do not stand here to support Governor Yahaya Bello, ex-Governor Yahaya Bello. I do not. I am not saying ex-Governor Yahaya Bello should not be made to face trial or to answer for whatever crimes he has been alleged to have committed. I'm not going to stand here to say that. But the issue is, once there is a legal process, then it must be obeyed, and then it must be respected, because we live in a society where the rule of law should ordinarily take paramount.
So in your opinion, the EFCC may have been wrong by going ahead with the attempt to arrest him, even when there was an order, from the 9th of February.
Yes. Look, my brother, we must come to a point in this country where we forget all this sensation and dancing to the gallery.
Who is dancing to the gallery? Are you referring to the EFCC now, or are you speaking generally?
Of course, by every means, I'm referring to the Economic and Financial Crime Commission. And I say this with very great sense of decorum and with great respect for whatever that institution has been set up to advance and to pursue. Now, there's an order of the High Court which you have acknowledged. Because I said they have acknowledged it because the EFCC actually took steps to appeal that order, which means they acknowledge the fact that such orders exist. Now the question is, do you now wait for the order to be vacated before in a manner that tells of gangsterism, ambush a particular house? And as at this time, we do not have any evidence that even ex-Governor Yahaya Bello was in that apartment. That's why I say it's dancing to the gallery. Now, the police, some 24 hours later, said they have recalled all the policemen attached to ex-Governor Yahaya Bello. Now, are you telling me that there were policemen with Yahaya Bello at that time? And you say you have a warrant of arrest to arrest him, and you are releasing a statement that Yahaya Bello is wanted. Those with useful information to produce him. And then in another vein, the IG of police is saying he's recalling the policemen attached to him. What is in this country?
Let's be clear. Yeah. Just to be clear, so we don't confuse anyone. The notice that his police personnel had been withdrawn, came after that standoff with the EFCC. As at the time when the standoff with the EFCC happened, he still, according to the stories, had police personnel, with him. Yes, I understand that many Nigerians ask, that why, if he's been declared wanted, why are you asking, his orderlies or withdrawing his police orderlies? Why don't you ask them to just arrest him? But let's have you watch the EFCC chairman narrate bits of what happened that day, and then we'll have you respond to it. Let's quickly share that with you.
Before court, go and check it. Apply for our processes, please. You will get some of these particulars of offense there. Move money directly from government to bring the change. Use it to pay the child's school fee in advance. In advance, dollars. How much? 70 what? In dollars, yes. In dollars. I think $72,000 or thereabout. $720,000, sorry. $720,000 in advance. In anticipating that he was going to leave government house. In a poor state like Kogi, and you want me to close my eyes to that, under the guise of saying I'm being used. Used by who? At this stage of my life, used by who? By who? For crying out loud. I assumed office here. I didn't initiate the case. I inherited the case file. I called for the case file. I called for the report. And I said, look, there are issues here. Do you know on my own, on my honor, I put a call across to him, which ordinarily I'm not supposed to do, just to honor him as a governor, as a immediate past governor. Sir, there are issues. I've seen this case file. Can you just come? Let us clarify these issues. I'm under camera. He said, sir, I thank you, my brother. I know, but I can't come. There's one lady, I don't know what her name is, that she learned she had said, she has surrounded the EFCC with over 100 journalists, to come and embarrass him and intimidate him and all kind of stuff. I said, okay, if that is your fear, I'm going to pass you through my own gate, special man's gate. You will come to my floor. We will accord you that respect. I will invite my operatives. They will come and interrogate you or interview you in my own office.
All right, I'm sure you've seen the clip there where he explained some of what happened. Now, further down in that video clip, he did talk about what exactly happened that day. And he did say that for those who were criticizing why they hadn't used force to break in, because as you know, Section 12, subsection 2 of the Administration of Criminal Justice Act empowers them to be able to use some measure of force to break in and arrest. So there were those who criticized why they did not use force to go in there and get him. And he did say that if they had done that, that there would have been violence. It would have led to people being hurt. So what's your assessment of what exactly the EFCC should have done in terms of how the arrest should have been carried out that day?
Look, I've listened very carefully to the EFCC chairman. My sympathy is not with the EFCC chairman. It is the Nigerian public who have been meant to go through this for decades or thereabout. Why do I sympathize with the Nigerian public? We see this drama being played every day, almost every time on the screens. Now, the EFCC chairman has just detailed how he put a call across to ex-governor Yahaya Bello and all of that. The question was, or would be, was there a formal invitation extended to him? What steps? The EFCC is a body established by law. There are procedural steps set out. Even when somebody like Yahaya Bello, for instance, fails to turn up and you have given him the benefit of the doubt, the investigations are clear, the facts are before you, there are steps you could take, even in arraigning him, even without his presence, even without his attendance. Very well. These are procedures set out in the EFCC Act. You know, my point is this. I'm not as much concerned with the veracity of the claims the EFCC has against Yahaya Bello as much as with the process. Now, there are three pillars upon which the rule of law, particularly as advanced by agencies like the EFCC, can stand. Number one, there's the procedural integrity. It means that the process by which these things are being done goes on properly. It means even the investigation, the arrest. You do it in a decent manner, you do it in an orderly manner, you do it in a digital manner, in such a way that you get to the root of the issue. Why do I say this? I've had several instances where this kind of dramas play out. This kind of drama played out in the case of Rocha Sokorota. Is Rocha Sokorota convicted now? No. This kind of case played out in the case of Adoki Bello. Has he been convicted now? No. He has been discharged by the court. Several instances like this.
So do you think that?
Why do you have to put the general public through this?
Yeah.
So is this one of those cases? Mr. Nyawule, is this one of those cases that the FCC is most likely going to fumble? And I mean, we've seen them in some cases before now fumble their cases, because you and I understand that the legal technicalities can actually frustrate a case when you haven't done your due diligence. So does this look like one of those cases that you just go to the media to spark up excitement and at the end of the day might lead to nothing? Or do you think that for the first time in a long while, we're actually going to get to the root of a politician being thoroughly investigated?
Exactly my point. I hope, for the sake of Olukayode, with due respect, is a learned senior, I hope the EFCC clean up its tables. We want to see that this is a case they can get right. We want to see that this is a case where we don't drift from the usual drama that the EFCC is associated with, and then we get convictions for the sake of public impact. Now, we want the average Nigerian citizen to have fear of consequences. We want the average Nigerian going into public office to have a fear that they will not just pass through this kind of drama, and at the end of the day, it's all wishy-washy. You go to court, there's no substance to the allegation. You file a 100+ count charge against someone, and all 100+ counts are struck out on a low case submission. I mean, what is going on here?
All right.
That's the point. I wish that this time around we can actually get it right. But
we'll see.
At all the
time will tell.
That has been going on,
only time will tell, and of course, the new EFCC chairman has that weight on his shoulders now to prove Nigerians wrong when they say that, it's business as usual. Remember that there's also Hadi Sirika's case, which of course, has just started. Nigerians, of course, are keeping a keen eye on the EFCC, and its ego. But I also want you to speak on the Naira mutilation, issues that we've had in the last couple of weeks. Some other people have also described it as, once again, just playing to the gallery by the EFCC, and it's nothing that they should stop wasting Nigeria's time. What are your thoughts on their charging these two prominent Nigerians to court for mutilation of the naira?
I would take a very deep and painful breath here. If you see my response to this whole Yahaya Bello issue, it does seem that I'm speaking again from the background of what has happened in those two cases. Kogi Bello, okay.
Ogunaya Idris. Okay.
Yes. Now, I'm even at a loss as to how to even describe him or her. Now, the point is this. I've been emphasizing the issue here that we should have an EFCC that doesn't just essentially play to the gallery. In the schools of legal interpretation, canons of interpretation, one crucial canon of interpretation is the mischief rule. What is the mischief that was in place that necessitated even the establishment of the EFCC and the enunciation of the Economic and Financial Crimes Establishment Act? It was out of international concern to address critically the issue of public corruption, particularly corruption as it pertains to those who hold public office, the issues of money laundering. That was a season where wads of cash was being seen in private homes of politicians.
Yeah.
That was a period where we're seeing monies locked up in Swiss accounts in foreign banks around the world. That was what bested the EFCC. And if you look at Section 46 of the Economic and Financial Crimes Establishment Act, you would find a background to the establishment of the EFCC. So look out for, to investigate, to prosecute matters that have to do with economic and financial crimes, geared towards the enrichment of those who have carried out those crimes. Now, the question you now ask yourself, where does the strain or the mutilation of the naira falls under the contemplation of Section 46 of the Economic and Financial Crimes Act? You are struggling to find it. You are struggling to see it. Now, we have had instances where the EFCC, and there's this viral video making the round of the EFCC acting like an Ekiti dog. An Ekiti dog that has a black head and a white tail. That dog leaves the compound they're supposed to guard, and then is watching out for other compounds and leaves these cases unattended to. Brother, there have been mind-boggling corruption of great proportion. And you want to wonder, these billions of naira, these trillions of naira that have been snatched away, we're even hearing dollars in their billions. If these monies were put to public use, what will be the loss of Nigerians? And the EFCC lists all those, which should be its primary concern, and are prosecuting people for mutilating the naira.
But don't you think the EFCC can do both? And of course, the Naira Mutilation Act is a CBN Act, by the way, but I think the EFCC then has a special task force that was set up for it. But don't you think they can do both? They can chase financial crimes and at the same time, pursue those who are mutilating the naira?
That is exactly the point. Now, we have institutions. The Nigerian police is there. Look, make no mistake. I'm not advocating that people go around abusing our naira. Make no mistake about that. But leave that to the police. It's your primary function. Assuming the EFCC, assuming the EFCC was doing its role, performing its function, and we have been seeing prosecutions, I've been seeing people rendering account for the billions that are stashed away from public coffers. We'll have no problem. We'll have no problem with them doing other miscellaneous things like going after those spraying in air. But when you abandon your primary purpose and then you are chasing, in Obike and Federal Republic of Nigeria, that the interpretation of the court there, in that case, the EFCC charged somebody for an attempt to subvert justice. And the court said, no, that is not your primary responsibility. Yes, his attempt to subvert justice is a crime, but leave that to the Nigerian police. In the case of Igwe Alezianoche, the Supreme Court has said that the Nigerian police, even in the case of Al Mustafa a mistake. The Supreme Court has said that the Nigerian police is the primary organ established by the Constitution to investigate and prosecute crimes. So when we have crimes established under the CBN Act, why don't we come to the police and face the case of corruption? Corruption is the greatest bane of this country. We are all evidence of that. And if we are going to win the trust and the confidence of the millions of Nigerians, particularly young people, a lot of them who mentally checked out of this country after the last general election, then we have to be seen to be doing things right. We have to be seen to make public officials account for public wrongs. That's the point I'm making.
Mr. Nyawule, on the final note, I'd like to find out from your perspective what the role of the judiciary is in ensuring that we bring a total cleanup. We're fighting against corruption. We're seeing the EFCC. You're talking about roles and assignment of responsibilities and how the police should step in certain areas. What is the role of the judiciary? And from your assessment so far, how has the judiciary fared in fulfilling its own end of the bargain?
Very true, because there's arguments that it's judiciary that fails the EFCC a few times.
Now, in a very painful manner, let me say that while we are having all these conversations about Yahaya Bello and all of that, like I said, my primary concern in discussing this has been a procedural issue. But let me tell you that there has been a failure of institutions. And the painful thing I want to say here, and I hope the world is listening, particularly the political class, when you destroy institutions of state, they will come back to haunt you. Today, the EFCC is saying that ex-party orders are being used to prevent the arrest of those who have cases to answer before them. In this country, an ex-party order was used to remove a sitting, the CGN, the Chief Justice of Nigeria.
Yep.
An ex-party order was used to remove him. Now, those are systemic destructions of institutions of state. And when you destroy institutions of state, sooner or later, it will come back to haunt you.
Mr. Abednego.
Said well in all of this, but they are categorical no. The judiciary has not paid well. And it takes us back that if we want to fight a war against corruption and win the war against corruption, there must be a Puritan effort across institutions of government, including the appointment of those who go to the bench. You cannot appoint people based on favoritism. You cannot appoint people based on cronyism, and do not expect them to give orders to subvert justice.
Mr. Nyawule, obviously, there's a lot of fixing that needs to go on, in the EFCC, in the judiciary, and the executive, everywhere. We would like, that you, of course, join us again to expand further on some of these aspects, focusing majorly on the judiciary and its issues. But thank you very much for stopping by this morning. We enjoyed speaking with you.